SJC-11460, Jane T. Polay, and another v. Joseph S. McMahon.
Mr. Chief Justice, may it please the court, good morning. I'd like to reserve 3 minutes of rebuttal time. My name is Philip Iliopoulos. We're here today to discuss with the court what we believe was the wrongful dismissal of 2 counts of my client's complaint, mainly a count for invasion of privacy and a count for intentional infliction of emotional distress. And it's our argument today that the Superior Court really applied a different test than what's well settled in Massachusetts as to how facts or allegations in a complaint are to be viewed as part of a 12b6 motion. It's well settled that factual allegations in a complaint and any such reasonable inferences as may be drawn therefrom shall be construed in the plaintiff's favor. But if you read the lower court's decision, it appears to be construed with quite the opposite approach, a request or a belief that certain allegations weren't substantiated by additional proof or assertions, as well as the Superior Court's role almost of taking on the trier of fact in the case. When we look at the invasion of privacy, what the complaint has alleged is that the defendant has several cameras trained on the plaintiff's property.
Is that what you would say is inappropriate behavior? Why can't I set up a camera in front of my house aimed across the street?
I think that you can set up any camera you would want on your house as long as it's being done so for a legitimate purpose, the security of your property. However, if the camera is trained not on your property or on the general public area, but trained on your neighbor's property, what we have is a densely settled neighborhood here, and those cameras are trained on the neighbor's property, surveilling them 24/7, and those cameras, the technology allows those cameras to actually see into your neighbor's.
Is that critical? Does
I don't believe it is. I don't believe it is critical. I think just by the fact of when you look at someone's right to feel private in their property, I think even just training cameras solely on your neighbor's property and recording their comings and goings on a 24/7 basis in and of itself would be an invasion of privacy.
Well, let's say I don't have a camera, but I just sit there and I look out my window at their property. Is that an invasion of privacy?
I don't believe that would. I don't think that would give rise to it because I think at that point you're just almost a casual observer of what's transpiring throughout your neighborhood. But when you're videotaping someone, and you have to look at what is the purpose of that videotaping. When you look at invasion of privacy, we would argue that the act of filming someone's property 24/7 is actually not a legitimate purpose, but an illegitimate purpose as part of harassing that neighbor. And we would say that given the technology that's used and the intimidation of knowing that your every move is being recorded would give rise to actions that are either serious or substantial.
Well, do you have to show some abuse? In other words, is it necessary for I've got a camera on my neighbor's house. It's on my property, and it doesn't intrude into any spaces that are within the house. Unless I do something with it, I mean, if I put it on the internet, maybe that would be a problem. But if I just record it?
Well, I guess it depends on what your intent is in recording. First off, we've asserted in the complaint in 2 separate areas that the cameras can see in my client's home. So that's clearly...
That's actually said only with respect to the invasion of privacy claim. It's not said before.
With respect to the invasion, it's listed actually in counts, in factual allegations common to all counts, as well as in the invasion of privacy claim itself.
I didn't find it. I found it only in that one place. Where do you say that it's pointed inside the windows is mentioned anywhere except on paragraph 64?
It's in the facts common to all counts. I could pull that out for the court.
Is this your incorporation by reference to all previous and subsequent paragraphs? Is that what you're referring to?
Right, and it does say, the complaint does say in facts common to all counts that the cameras can see through the windows. But getting back to the original question, I think that with regards to the recordings, we have alleged in the complaint that the recording is part of a overall effort by the defendant to harass and intimidate my client. Those allegations, again, we feel that the Superior Court, the lower court, in looking at the allegations, instead of focusing on the act of continually recording their comings and goings to harass and intimidate them, being able to see in the windows, the court incorrectly likened what the defendant was doing to what Google does with Street View. And if you ever have been on Google Street View, that takes a snapshot in time maybe once a year of a state, a city, town, or a neighborhood.
Actually, backyards of people's porches, and porches too, because I...
Absolutely. So you can sometimes zoom in and see a property.
Except former Vice President Cheney.
Yes. But that's not a continual, and the court said in those cases that Google has a legitimate purpose. They're not doing it to spy on that neighbor. They're not doing it to intimidate, to harass. They can't see in the neighbor's property. They've got a legitimate purpose of doing that to provide maps for people so that people can
The allegation
find.
seems to be, or the cross here, that the legitimate purpose, as I take it from this, is that your clients are actually engaging in activity that's bothersome to other people, and they're trying to catch them at it, lurking in the bushes, maybe pointing something in their eyes, pushing a child off a bike. They're trying to catch them in the act of engaging in inappropriate conduct directed at others around them. Is that okay, or is that, and if it is, first, is that okay? And then, is it subject of a trial? Is that what you're saying?
All we've heard on the defendant's side is that their sole purpose is just the protection of their property. That the cameras aren't actually being set up for that particular purpose. But so I don't know that that's necessarily the reason the defendant has given for it. But again, I would say that if you're using that technology to see into someone's house, where the right to privacy has really been held to the highest level, that would be enough, at least to certainly get through a 12b6 motion for dismissal. I mean, really, I think it would be up to, quite frankly, the trier of fact to determine whether the purpose was, in fact, as Your Honor has mentioned.
So is it your view that every invasion of privacy is extreme and outrageous, which is the element that's required to make it an intentional infliction of emotional distress?
Well, I would say that the level of invasion of privacy that we've alleged in the complaint, the continual recording, the video recording, the multiple cameras, it's not just one camera pointed at the house, but they would add later on other cameras on a different part of the house also pointed at my client's property. So you've got this sort of feeling of, we're going to continue to ratchet up the intimidation and the harassment by adding yet a third camera or a fourth camera that will be focused just on your property. So I think it's the level, it's the specific facts in this that we've alleged that certainly give the trier of fact the ability to find that it was both unreasonable and either serious or substantial.
Okay, but that's different from extreme and outrageous.
Well, if we're looking at now in terms of the count for
Right,
intentional
and
infliction of
I'm
emotional
asking
distress.
you whether or not every violation of count 4 is also a violation of count 2.
I would argue that it certainly could. It could be certainly in and of itself enough to give rise to that. But we've certainly alleged other actions by the defendant that give rise to our emotional distress case. They're meeting with other neighbors to conspire to drive my client out of the neighborhood, to making lewd and comments, gestures, to acting as if, while my client is walking down the street, they were going to hit them with their car. I think taking all of their behavior in totality, certainly the trier of fact could find that that was extreme and outrageous behavior. So, but I think certainly to your point, videotaping someone on a 24/7 basis, looking into their windows.
Well, I guess that's
That could-
one question. I mean, we can differ. I don't think you're right about it being anywhere except in the invasion of privacy count, but we'll look at it again. But without that, do you have intentional infliction if you're merely pointing it at their property?
If all we had in this case was a video camera being pointed at someone else's property, I wouldn't argue that that in and of itself would give rise to intentional infliction.
So it's critical that it's seeking to look inside the house.
I think if that's the only allegation you had in the
Let's
complaint.
assume you got bad faith too. I mean,
Yeah.
there's bad blood, but if it's just looking at the front yard or the front of the house, is that enough, or must it actually be attempting to intrude as to what is going on inside the house?
I think that this court, if this court could, or if a court or a trier of fact found that the purpose, the intent of those cameras being directed at that person's house, whether they can see in the windows or not, was part of an overall effort to harass and intimidate them, then I think the finder of fact could in fact find that that would also be extreme and outrageous conduct warranting a finding under the intentional infliction of emotional distress. So I think you have to look at the intent, the actions themselves, and these would be things that a trier of fact would glean and determine, rather than a court determining at a 12b6 motion, where there's required as part of case law to take our allegations as fact and to draw reasonable inferences in our favor, and really, I think, went the opposite way, trying to find or draw inferences against the plaintiff.
Counsel, we'll leave it there for the time being. You'll be back.
Thank you, Your Honor.
All right.
Good morning, Your Honors. Richard Moynihan for Joseph McMahon. I think as my brother just indicated, there's no dispute here that these properties are in close proximity. They're in Lowell, in a tight community. They're separated only by the public way. Beyond that fact, and I think the lower court found that much of this complaint is filled with speculation and conclusions. And the main issue with respect to the invasion of privacy is these cameras, why they were put there, and what they see. My brother has indicated, and the complaint alleges, that the cameras are able to see within the windows of the house, that they were put there with the intention to harass.
Well, why isn't this a classic case that needs to get to summary judgment?
Because, Your Honor, I think that there's...
On the invasion of privacy, just take that one.
On the invasion of privacy, because the facts alleged do not warrant a finding, even if everything in the complaint is deemed true, that the actions were serious or substantial.
Really? I mean, if in fact it is true that these cameras are pointed at your house, that they can see inside your house, and they're done for the purpose of harassing you, my goodness, I can't think of a worse case of intentional, privacy violations.
Well, with respect to what the cameras would see, I would...
They've alleged that they can see inside the house.
They have. But, Your Honor, if you look at appellant's brief, it appears that in the brief they admit that that allegation is based on their reasonable inference, based on the proximity of the houses.
We're talking about a 12b6 motion here.
Right. The point is, Your Honor, I would argue that the cameras, they haven't alleged that the cameras pick up anything more than Mr. McMahon could see from his own property or that the public could see from Westview Street. They haven't alleged that the cameras are invading into some secluded place within their house. Again, both houses are in close proximity to the street. I would look to Judge Gantt's decision in the Superior Court in DiGiloramo, as one of the Massachusetts cases that somewhat looked at an invasion to the interior of someone's property. In that case, Justice Gantz looked to criminal law and made a distinction between the use of enhanced vision and unenhanced vision. There's no allegation in this case that
Right, but
these
that
cameras...
that was not 24/7. That was just an investigator attempting to look to see that somebody was mobile, was not injured
Yes.
inside their home, so.
And I will only use it for...
Right. I mean, I
broad-
understand,
a
I
broad-
understand that part about it. We don't know whether or not there was any enhancement, but that was short-term. That was not 24/7.
Correct. There has been no allegation that there's any enhancement of the cameras on the house. There's been no allegation that the cameras can capture anything that Mr. McMahon could not see from standing next to the camera on his own property. It's clear that there's no allegation that Mr. McMahon ever left his own property or trespassed upon the plaintiff's property. So we're only dealing with what this camera potentially could pick up from his property of the neighbors across the property. Now, again, they have alleged that it can see inside the windows. Well, Mr. McMahon, potentially, given what is agreed is a close proximity to this house, could also see in the windows. Anyone else going up and down the street can see inside their windows.
What's the, what did you say the distance was between these two houses?
I don't have a measurement for you, Your Honor. I think both parties have used the terms, the close proximity. That is the term used in plaintiff or appellate's brief. It's a Lowell street that, a single lane street. It's not a double lane street. And there are not sizable front yards on either property.
Let me ask you a hypothetical question. If a person had binoculars or a telescope and they looked across the street into a neighbor's home, would that be an invasion of privacy?
I think that gets more into an invasion of privacy. Yeah, absolutely. Again, looking back to your decision, Justice Gantz, that would change the expectation of the person being surveilled. Again, if the plaintiffs are inside the windows on the front of their house, they have a reasonable expectation that if someone's walking by on the street, or if Mr. McMahon is in his front yard across the street, that if they're in front of the windows that face the street, he could see them.
Yeah,
if
but
windows
the
are open.
expectation the expectation is the person will keep walking by. They're not going to stop and stare and look through the window.
Well, it goes to, I think, what Chief Justice Ireland asked. If Mr. McMahon sat on his stoop, on his front steps, 8 hours a day, just staring across the street, has he committed an invasion of privacy? Does he not have some right to sit and look from his own property? So I would argue that it doesn't change that analysis. If you're now using magnification, you're using a telescopic lens, you're using binoculars, you're peering much further into those windows, into the interior of that property, beyond what might be seen close to the window, that does change the analysis. Now you're getting
Isn't that why you need the facts?
I think it's incumbent upon the plaintiffs to allege facts beyond what we have here. And again, I would go back to Judge Walker in the lower court, look to this particular fact, that they allege that they record 24 hours a day and they allege that they can see inside the windows. There's nothing to indicate that that is anything more than their own speculation. And again, in the appellant's
This is an
brief,
allegation and a complaint. I mean,
in the
do you,
appellant's brief, he admits that it's inference based on the proximity of the properties.
do you think that, what's your response to the argument that it does seem that Judge Walker kind of was looking at this from the perspective of not the fair and reasonable inferences in the plaintiff's favor from facts stated, but the actual opposite? You
I think
disagree
he-
with that?
he-
You think that that's,
I
that his
think he
analysis
looked at
was
the
absolutely right?
universe of evidence that was presented to him, which included court documents from other courts, the Lowell District Court, the U.S. Federal Court, U.S. District Court, in probably looking to whether or not the complaint plausibly suggested that they were entitled to relief. And in that, again, we could look to, and I think Justice Duffley had asked about the motivations of my client. And of course, it's alleged that he intended this. There's no allegation as to how they learned the subjective intent of my client. But if you look beyond the four corners of the complaint into the other materials within this record appendix, you'll see that at the times these cameras were installed, there was an active harassment prevention order against both plaintiffs in favor of my client. a reasonable inference can be drawn that the intention was not to harass, but court documents and a Lowell District Court finding means or justification for issuing that order.
It's all appropriate because it's a matter of public record that he can take judicial notice of? I mean, it's not part of the complaint, so I'm just interested in how you get there. Is that how you get there?
Yes. So I think the justice looked to the allegations. Certainly, the allegations as to when these cameras were installed on my client's property are very specific. They have specific dates. So clearly, the plaintiffs themselves were able to surveil my client's property with sufficient ease so as to know exactly when these cameras were installed. But again, it doesn't go to they're alleging that he intended to harass them, and aside all the other complaints beyond the cameras. If this is allowed to go forward, it opens up, these home surveillance systems are widely available in Best Buy or Walmart, wherever you might go. How many people in eastern Massachusetts that may use these in closely knit neighborhoods are now going to open themselves up to lawsuits based on disgruntled neighbors who argue that my neighbor put that up because he wants to look at me all the time, it's bad faith, he can see inside my windows, even though he can see inside my windows from his kitchen or from his own living room. There has to be more heft to the complaint to get past the initial stage to say, yes, they've put this camera on there, my neighbor has put this camera on, he told me he saw me in my kitchen, which is in the back part of my house. He told me he saw me doing something private within my house. My neighbors told me that he said he saw me doing something more than just bare allegations that it's with bad faith and that it can see in the front windows, which are clearly open to public view.
It doesn't say front windows, it just says windows.
Well, windows.
Well, it could be.
If the houses look at one another, so I would infer that it can't see the back windows. So I would argue that this court needs to look a little more beyond into what privacy is being invaded. And this complaint does not give nearly enough to indicate that some place that the plaintiffs have a reasonable expectation of privacy has been invaded by these cameras. With respect to the intentional infliction of emotional stress, I'll largely rest on the brief. I believe, taken as a whole, everything true in this complaint, verbal attacks, the installation of cameras, a concert with neighbors to allegedly drive them out of the neighborhood, it alleges bad faith, it alleges annoyance, it alleges a number of things, but it doesn't allege extreme and outrageous behavior that gets to the level of what the case law has described that to be. My brief included a number of examples, which I think clearly are of a different magnitude than what we have in this case.
Now, with regard to that, what do we do with the allegations that were knocked out on the special motion to dismiss the claims of malicious prosecution and abusive process? Are those to be excluded in evaluating, are those allegations to be excluded in evaluating the intentional infliction of emotional distress claim?
If they're not specifically tied to that claim, I know Your Honor has questioned my brother as to the specific facts that may be tied to that. If they're not specifically tied to the intentional infliction of emotional distress claim, I don't see how that they could
But
be.
even if they were, to the extent that they're protected under the anti-SLAPP statute, what do we do with that? Meaning the petitioning of the court is protected, and that's why the judge granted the special motion to dismiss, and we haven't discussed the issue of attorney's fees yet, but can you use those allegations on a different claim?
Your Honor raises a interesting question. You have a lower court judge that has determined that those facts, the complaints about the filing of police reports and whatnot, were inappropriate under the anti-SLAPP statute. Based upon that, it would seem to reason that to use them again as grounds for an intentional infliction of emotional distress may in fact be inappropriate, because a court has already decided that what has been alleged or the behaviors were done so again contrary to our law. With respect to the attorney's fees, that's the final issue I think Your Honors are handling. And I don't know that I'll go into too much detail because I think it's relatively clear that the statute says shall. I mean, it's unmistakable. The court's prior decisions have indicated that attorney's fees and costs, an award for a successful litigant, with respect to a special motion under the anti-SLAPP statute are mandatory. So what my brother has raised is whether or not there's a proviso to what you have said is a mandatory award when the party bearing the cost is not the actual litigant. I would argue that that is irrelevant. My client in this case paid a premium for an insurance policy. That insurance policy includes liability provisions that provide for his defense in situations exactly like this. That is what is occurring. I have pointed, Your Honors, to two cases, one from California and one from Indiana, that have addressed this exact issue, and they have both said that it would go against the intent of the statute to exclude the award of attorney's fees and costs in situations where the fees are borne by a third party, like a liability insurer, because the intent is to shift the burden and the cost for such situations upon the party deemed to have abused the judicial system.
But do you agree that it's focused only on those claims which are dismissed by the anti-SLAPP statute?
Yes, and I put that in my brief in the lower court. I made clear to Justice Walker that there is case law that says that it's the discretion of the judge when it's been a partial award, which was what we had in this case, that the judge can take that into account and so diminish the award of costs and fees. Judge Walker chose not to do that. I also included within the fees submitted.
Were there any costs with regard to the fees submitted that related solely to the other claims and had nothing to do with the anti-SLAPP claims? That is,
I do not believe
research
so.
on intentional infliction of emotional distress that would have had no bearing on the claims that were dismissed.
I would have to review the bill again. It's in the record. It's possible. It's possible that there was time spent doing specific legal research on an issue like intentional infliction of emotional distress exclusively and identified as such. Again, I submitted a full bill for work because the case law indicated that at the discretion of the judge, it's not limited to just the special motion. The statute and the case law indicates that the judge can consider everything. So I submitted everything for him to consider.
Thank you, counsel.
All right, thank you very much, sir. Rebuttal?
If I may, just a couple of points. To Justice Grant's point, I don't believe that if 2 of the 5 counts are thrown out under a special motion to dismiss, that in any way takes away the allegations that are part of facts common to all counts on the others, on the other matters. So certainly the facts, the allegations in the entire complaint can still be applied towards intentional infliction of emotional distress. You don't throw those allegations out just because 2 out of the 5 counts were taken out under.
So allegations that he petitioned the court for relief may bear on your intentional infliction of emotional distress, even though they are barred under the anti-SLAPP statute to be brought as abusive process or malicious prosecution?
Where we've alleged that they were done, that the defendant made statements, made complaints to the police that were solely for the purpose of harassing them, intimidating them.
Isn't that one of the defenses against an anti-SLAPP motion? That is, that it's wholly without basis in petitioning activity? So when the judge, in other words, so when the judge grants the motion, implicit in it is a finding that it wasn't based on what you're just saying.
Well, I still think that it can be used to show some motive by the defendant taking in total their actions on some of the other counts. I would also say that with regards to the inference that my brother stated that was in our brief was that the court, even without the allegation that these cameras can see through the windows, given the close proximity of these houses and the technology that exists, the court themselves could have inferred that the technology would allow these cameras to see in the windows. So it was the reference just to inference. And then with regard to fees, I think it is important to note that 2 out of the 5 counts were dismissed, but 3 out of 5 were not with regards to the special motion to dismiss. And there is case law that says that it would be reasonable to make an adjustment on those award of fees. And to also answer Justice Gantz's question, the court awarded 100% of the fees in this case, including the fees related to the dismissal under 12b-6. The statute talks specifically about the anti-SLAPP statute and related discovery. Here, the lower court awarded attorney's fees even on my brother's work to prepare the motion to dismiss under 12b-6 in the memorandum. And we'd also argue one final point, that the statute's pretty clear. It talks about the costs that are of the moving party, the costs they incurred, not a third party, not costs arising out of the litigation in general, but costs to the moving party. And here you do not have the moving party incurring any costs. And I think that's where the Norwood case is instructive, because that's really the only case that I could find where the bankruptcy court was looking at Massachusetts and applying the laws they saw it.
So if you have a group which is picketing some large organization claiming environmental harm, and the company sues them for something which would fall within their right of petitioning or of assembly, and a pro bono law firm or a public interest law firm says, we're going to defend this environmental group and they incur legal fees, you would say they get no attorney's fees?
I would, because I would say that the intent of the statute is to make them whole. They have not suffered any loss, they have not incurred any costs, so they are already made whole based on the fact that they haven't incurred any fees. It was really to protect more so the moving party, to make sure that they weren't incurring expenses if they could, in fact, survive or be successful on an anti-SLAPP motion.
Thank you,
All
counsel.
right, thank you very much.
Thank you very much.